Okay, good morning. The Medical Board of California Panel B meeting is now called to order. Can we have the roll call, please?
Morning and welcome. Dr. Donadev?
Here.
Dr. Levine? Here. Ms. Pine? Here. Ms. Shipsky? Mr. Tagami?
Here.
And Dr. Lowe?
Here. Okay, the first case that will be heard will be the oral arguments on the petition for reconsideration from Enrico Melson, MD. I'd like to turn the proceedings over to our judge for the morning.
Thank you, Doctor. Okay, let's go on the record. Okay, this is, my caption reads, in the matter of the accusation against Enrico Antonio Melson, MD, physician and surgeon, certificate number G59473. This is case number 17-2011-212848, but as Dr. Lowe mentioned while we were off the record, this is a time for the presentation of oral argument relating to the board's decision to reconsider the decision in the matter which I have identified. My name is Carl Engemann, Administrative Law Judge assigned to hear this matter, and we are convened in Sacramento on July 18, 2013. And even though we've had a roll call, may I, starting from my left, have the panel members identify themselves for the record, please?
Philip H. Tagami.
Sharon Levine.
Dave Ganadev.
Denise Pines.
Okay, thank you. And may I have the counsel identify yourselves for the record, please?
Good morning, Cindy M. Lopez, Deputy Attorney General for Complainant.
Thank you.
Good morning. Jason Ross, representing respondent, Dr. Enrico Melson.
Okay, and Dr. Melson is present, correct?
Yes, Your Honor.
Okay, thank you. All right, I think the parties know that the protocol established by the medical board, and this is panel B, is to allow 15 minutes of argument for or by respondent's counsel, followed by 15-minute response by the Deputy Attorney General, and then 5 minutes beginning with respondent's counsel for rebuttal argument, and concluding with 5 minutes from the Deputy Attorney General for her rebuttal. You know, in the past, it's been useful to have just a brief summary of how we got where we are. Are you, Ms. Lopez, are you inclined to provide that to the panel?
Sure.
Okay, thank you.
This will be very, very brief. This is a very straightforward case. About 2 or 3 years ago, the respondent pled guilty to a violation of the tax code for failing to file income tax return with the intent to evade payment. He pled to that, and he was put on criminal probation. He was put on formal probation. We filed an accusation. It went to hearing in several months ago. He was the only witness. The ALJ found that we proved the case by clear and convincing evidence. The ALJ then issued an order which had no, and I repeat, no probationary optional conditions, just the standard conditions, 5 years probation, that was it. And then respondent filed a petition for reconsideration. He's asking the panel to lift the prohibition of supervising physician assistants. It's a very standard term, and the panel granted the reconsideration. To be honest and straightforward and direct, I'm not sure why it was granted, but that's how we got here today.
Okay, thank you very much. All right, Mr. Ross, please.
Good morning, everyone. Thank you for allowing us to be here to have this matter reconsidered. I know that case law pretty much says that a conviction is directly related to the practice of medicine. In this case, we believe that this is a very unique case where Dr. Melson's conviction is not substantially related to his practice of medicine. Dr. Melson has been practicing for over 31 years with an emphasis in global integrative medicine. Over the 31 years, he has had very little encounter. I think he's had one incident that was resolved as far as any blemishes to his record as far as malpractice goes, and he can explain that. But the conviction related to evading taxes with the intent to defraud. He had never had the intent at the time of his plea bargain. One of the things, and I know it's not here to be considered, but we are in the process of appealing that because he did have inadequate representation in which led him to take the particular plea. Dr. Melson was in the country at the time. He was traveling from New Zealand, and the person who was representing him was suspended from the practice of law not too soon after his plea bargain for use of drugs. So that person, even at the time, Dr. Melson did not know. So that is one mitigating factor, was just in him taking the plea, he did have inadequate representation. So when he was explained what he was pleading to, he was under the impression that he had no intent to evade. He knew he was late on filing his taxes, so it was more of, okay, plead to this. He's in jail. He needed to get back to New Zealand. He was in the country. When he found out that there was a warrant for his arrest, he immediately made accommodations to come and deal with that. So he was actually met by the officials, which was prearranged. His arrest was, his surrender was prearranged. There was no running. There was full cooperation. The only challenge was that he was not, even though it may have been explained to him, but his attorney did not fully explain the ramifications of taking that particular plea. So one of the things that's very crucial is part of his plea was to pay restitution. However, the restitution was based upon what was a default calculation by the Franchise Tax Board. Dr. Melson had a tax obligation, a default tax obligation for over $955,000 in the same year in which he pled in 2005, which this stemmed from. When that obligation was reviewed by the Federal Tax Board, or the IRS, that $955,000 obligation was reduced to $126.78. When the Franchise Tax Board reviewed, well, basically, we were having a challenge even right now in dealing with the Franchise Tax Board. Because of him taking the plea, the $139,000 or so that is claimed to be owed is based on the default, but is tagged as restitution, but not necessarily something that has been reconciled by the actual tax board. So I think these are points that need to be understood because Dr. Melson has never been one to, although he may have been responsible for filing taxes late, he has never been one to purposely or with the intent to evade taxes. The actual event or the tax year in question is 2005. The conviction was in 2011. One of the things that we noticed, or that was in the previous administrative law judge's decision, was how the degree of the punishment was evaluated. So one of the things that some of the factors based on the California Code of Regulations, Title 16, Section 1360.1, provides that if a physician is convicted of a crime, the criteria for evaluating rehabilitation are the following: 1, nature and severity of the acts; 2, his total criminal record; 3, the time that has elapsed from the crime; 4, whether the licensee has complied with terms of parole or probation and restitution; 5, any evidence of rehabilitation. So they went through each, the AHL shows that he went through each factor. He found that the conviction was recent. However, the conviction was recent, but if we're talking about the crime itself took place in 2005, some 7 years ago. The nature and the severity of the crime was moderate. So crime versus conviction, moderation, is it based because it was 139,000 old? I'm not sure exactly how he got moderate, but he did not get severe. And this is his only criminal offense. And there was no evidence that he was non-compliant with probation, which he's been complying with all terms of his probation. And a key point is that there is no evidence that he has ever endangered the public. One of the key things that we're disputing in the punishment is his non-ability to supervise physician's assistants. And the probationary period in which was granted is 5 years, but it's 2 years after he's even on for his criminal probation. So we think that the probation period is much more, the timing is too long if the probation has to stay at 5 years. One of the things that is a big challenge right now is this has been impeding his ability to seek work. A lot of the positions that he's has applied for and been considered, and being employed is a key factor in him being able to meet his obligations to his children, his obligations to even pay the restitution that is required of him if he is unable to obtain, if he's unable to be gainfully employed. So I've done a little bit of research. It was very difficult to find here in California where where there are facts similar where we have letters of reprimand, but in other states and other places with the charges that were even more severe related to tax evasion, only a letter of reprimand was granted. We think with Dr. Melson's substantial history, most of Dr. Melson's work has not been money motivated. And that's part of the challenge that we're here. Most of his work has been in the indigenous communities. He's well known, he's traveled, but mainly practicing for the greater good of humanity. And so, whereas it is understandable that, he may have in the past placed little priority as far as financial, he is definitely remorseful, understands the importance of filing taxes. Most of even the taxes over the years, he's had very little obligation to pay back to the Franchise Tax Board as well as to the Federal Tax Board. He lives a modest lifestyle. He is one of the main things, even in part of the petitioner's filings, is that they found that he was competent and a caring physician. So to be punished so harshly, we think that this is a very unique situation that should be reconsidered based on the following facts that we presented.
Okay, thank you. All right, your response?
Yes, good morning. I find it interesting that counsel starts his argument with the issue about this conviction not being related to the practice of medicine, and I want to quickly put that aside. First of all, this was not an issue that he even raised in his petition for reconsideration. The judge found that it is substantially related. There's actually a case right on point. It's called Wyndham. I apologize, I don't have the case site. But literally this exact same conviction has been found to be substantially related. That's not really the issue in this case. And again, this is based on the petition for reconsideration filed by respondent. The issue is, should this panel lift the standard condition of not being able to supervise physician assistants? So let's talk about what he was not given. As a panel is aware, there are model disciplinary guidelines. You vote on those. You're the one that sets those. Those are the guidelines that every DAG, when we call our settlement person and talk about settlement, that's where we start. Now, they are guidelines. This is not the law, they're not required, but it's a place to start. Now, you can stray a bit from the guidelines if there's aggravation. In other words, you can give more discipline than what the guidelines say. Or you can stray a little bit if there's mitigation. In this case, in this case, these are the minimum guidelines for a conviction such as this. Community service, he was not given that. Ethics course, he was not given that. Psych eval, he was not given that. Medical treatment, he was not given that. So far, that's 4. A billing or practice monitor, he was not given that. Solo practice prohibition, nope. Prohibited practice, no. And victim restitution. I just said 8 conditions from the optional conditions in the guidelines that respondent was not given. And now he comes before the panel, not only is he given, in my experience, the most lenient discipline I've seen for a conviction case, and I've been doing this, I can't even believe I'm going to say this in public, for 20 years, but I know, I look so much younger, you're shocked. But he's now saying, not only do I not have these 8 optional conditions, but I want you to lift a standard condition. Standard means standard. It's a condition in every single probation case. It's a condition in every case where there's a stipulation, where there's a hearing. I do understand his problem in getting a job, and I do have to say, this is a respondent that is a little bit different than many of the respondents I have seen. He's not motivated by money. He does want to give back. He does want to work in communities where patients are usually not given great care. The problem is, he has this conviction. And the ALJ did not even write in his proposed decision why he strayed, why he didn't give one single condition. Another issue, counsel again, not only started with the irrelevant, no disrespect, issue about this not being substantially related, the plea. We're not here to talk about the conviction. He pled to what he pled to, which is with intent to evade paying taxes. It doesn't matter that his counsel was incompetent. That's not relevant. When you plead, you're not allowed to then come before the board and attack the conviction. Counsel also comments about comparing this to other cases. I can tell you that if you look in the action report and you compare this to other cases, doctors do not get PLRs for a conviction such as this. The reason why this is substantially related to the practice is the idea of honesty. If you are purposely evading taxes, you're not the kind of person that the public maybe can trust. If you're evading taxes, what are you going to do when you file insurance claims? What are you going to do when you meet with a patient and maybe you're not honest and truthful? That's why this is substantially related. That's why there are so many conditions when someone gets a discipline like this. He says that he's punished too harshly. Again, going back to my issue, he is being punished leniently. And I'm sorry, I shouldn't even use the word punish. He is being given a lenient discipline. And with all due respect, and again, to be very direct, if this panel adopts what respondent is asking, and you lift this standard condition, this is going to set a very bad precedent for other cases. I can tell you that respondents and respondent counsel, they talk to each other. They know about these cases. And if you, for reasons that I would not understand, if you lift this and don't even follow this very minimum discipline, then it undermines my ability, my colleagues' ability, when we go in front of OAH, when we negotiate settlements with other respondents, it undermines our credibility. Because if they know that they can just file a petition for reconsideration and the panel is going to completely stray from the guidelines, why would they ever settle? They wouldn't. They're guidelines so that we can start start at the same place in these kind of cases. They're guidelines so that you can be consistent in your discipline. So it doesn't matter if a doctor is in LA and has his conviction or San Diego, because we have these guidelines, they should be consistent. Again, and if Dr. Melson speaks, you will see that he's very sincere, but on the four corners of this decision, there really is no justification for lifting this PA prohibition. Thank you.
Okay, thank you. All right, Mr. Ross, you have 5 minutes to respond.
So one of the things that petitioner made clear is that this is clearly a unique case. This is not the standard case. And we're appealing to the fact that this is not a standard case. This is a very unique situation that should stray. And that's why there are exceptions that we are asking to be made in this particular case, because it just doesn't, this particular punishment does not fit this particular scenario. And we want to be very clear that even giving a little bit of the history, this whole tax obligation came from another doctor who had been convicted and was convicted for the particular crime. It was not Dr. Melson that was related to, it was a Medicare fraud case involving another doctor in which he was working at that particular clinic for about 6 months, in which that particular doctor fired him and didn't give a reason as to why. We can guess maybe now because he was using Dr. Melson's medical license number fraudulently. But again, the tax liability was reduced from $955,000 to $126. And we talked about honesty. Dr. Melson is of the utmost integrity. And again, when he learned that this was a major issue, he was cooperative and did everything possible to cooperate with the authorities. So again, we definitely want to strongly ask that the probationary period be reduced and that the prohibition against him supervising physician's assistants also be lifted.
Okay, thank you. Ms. Lopez, your response.
Actually, I think the same comments were made previously, so I'll submit it if there's no questions.
Okay, does the panel, let me see, I think it's up to the panel whether they wish, oh no, it's, the ALJ shall offer the physician opportunity to address the panel. So, Mr. Ross, does your client wish to address the panel today?
Yes.
All right, doctor, I'm required to swear you in, so would you please stand and raise your right hand to be sworn, please? Do you solemnly swear or affirm that any testimony you shall give in this proceeding shall be the truth, the whole truth, nothing but the truth?
Yes, I do.
You be seated. And would you state your name for the record?
Enrico Antonio Melson.
Okay, go ahead, doctor.
Thank you. First of all, I'd like to say that I honor very much Deputy Attorney General for her character and professionalism and for her sincere belief in upholding the standards of the state of California. That having been said, I'm also saying that I am a victim of the bureaucratic conundra that sometimes are laden within the process of the state of California. I have not ever in my life evaded taxes. I will go to my grave stating that. I will not accept someone's telling me or telling others that I am dishonest. I am not. Thirdly, I have dedicated my life to serving this entire planet. If you have seen in my file, you will see the numerous titles and accolades that I have received because of that. Why would I come back here and be a dishonest tax evader? It makes no sense. I recognize the technicalities within the penal code. I understand that. But I also would like everyone here to know that if there is no change in the decision of the prior administrative law judge and that prior hearing that it is due to a technicality in interpretation and application of laws. It is not due to the particularity and individuality of this case, as far as I am concerned. I am not an attorney, but I am the person who has lived this. I've lived this all over the planet. I've written articles that have gone to presidents. I've consulted with prime ministers. I have gone years without income, and currently, in the last year and a half, I have been able to barely make $50,000. I have not had any income at all in the last 2 months, and that is due to not simply the issue on the physician assistant matter of supervision. It is also due to the fact that there is a systematic stigmata in place, as you all know, for anyone who has a criminal conviction. That stigmata has cost me now over 30 job offers in just the last 3 months. I have had offers where I have been about to jump on a plane to go and sign the contract, only to be called back and told, sorry, we've reconsidered. So even if I am to have to handle this technicality of restitution for taxes which I do not owe, unless the state of California is going to decide it's going to overrule the IRS. If the state of California decides that it's overruling the IRS and is going to assign me a tax obligation of $139,000, then I would like to have that in writing. And thus, this is also part of the process that we are dealing with. No matter that it is an issue not to be debated here by the tax board, it is nonetheless a truth. I stand here at risk of perjury and risk of incarceration or at risk of being tossed out of your courtroom, Your Honor, by telling everyone here it is BS when someone declares me dishonest, when someone declares me a willful tax evader. I also ask the question, how could I be a willful tax evader if my tax obligation is zero? I was a late filer. I had incompetent counsel. I accepted putting my name on what I was given as I have no choice other than to go back in that other door and go back in behind bars, and you can never go back out to New Zealand and continue your practice, and you've got all of your patients waiting for you. I've dealt with the fact that I've got to get back to work, curtail much of my career activities in international health in order to be here, roll up my sleeves, stay put, go to work 60 hours a week, make as much money as I can in allopathic medicine, and send it to the probation department and on to the franchise tax boards for taxes which I do not owe, and get this thing done. However, I am being systematically excluded from that. And that has to do with the hearings that has preceded and the judgment that has been proscribed. Now, I'm willing to go to Alaska. I've lived in Alaska, the coldest part of Alaska. I'm willing to practice medicine any place on this planet, and I am one of the few people who has demonstrated that over the last 30 plus years. I'm willing to practice medicine under any conditions, and I am one of the few people who has demonstrated that in wars, in disasters, in jungles, in places where most physicians will not go. I'm willing to do it in California. However, I am being precluded from that by virtue of the inconsistencies in this case. Because of all of that, I cannot even also apply for recertification with the American Board of Family Practice. I have been certified in multiple medical specialties. I am one of those highly credentialed doctors in this country and on this planet. And yet, because I did not continue to keep my American Board of Family Practice certification current, because I have been also practicing in many other fields. When I come back here and I look to get my certification updated, I am precluded by this very same restriction status that says you are on probation. When I go to work in these community clinics, in these indigent care environments, now I'm told you can't get a Medicare provider number. You can't get a Medi-Cal number. The insurance companies don't want to pay for you because you're a criminal. You can't supervise physicians, assistants. You can supervise doctors. You can run the place. You can run the health department, which I have done in the past. But you can't supervise a physician's assistant, therefore we can't use you. We can't even use you to work as a physician's assistant very much, to have someone assign for you because you're a doctor. We don't have a basis for someone co-signing for you. That's not transparency. So it is a catch-88 rather than a catch-22 that I find myself mired in this particular quandary and quagmire. I have no direct challenge to the intent and the letter of the law. However, I know the truth. My understanding and what I have upheld in terms of this state and this country all around this world is that there is a law and there is justice and there is truth. And there is also bureaucracy and technicality, which sometimes is not consistent with that law and with that truth. I happen to be one of those where if there is an application of Murphy's Law, it's likely going to find me. I recently had some money come to me that I could live on because I've only been able to make the bare bones minimum and hardly anything else. And that was a refund from the IRS. That refund came after I had to make more than 24 phone calls to the IRS because they lost my forms for over a year. And they realized that, oh, we thought you owed us, but we realized we owe you. I received a refund from the state of California for the year 2010. That refund was applied to this obligation with me on the telephone with the representative from the Franchise Tax Board. I checked on my payment records. It is not even located in my payment record within the county of the probation department as being credited towards the restitution. We know that there are multiple ways in which the difficulties of the bureaucratic system and its continuity and contiguity are substandard, sub-ideal. We understand this. I have to deal with this. I've dealt with it all my life. It is one of the issues that we're having to deal with in our legal team. The legal team, which, by the way, is working pro bono in my case. Sometimes I can barely make my $500 minimum monthly restitution payment because I don't have any income, and I got to pay for my daughter and child support and her education requirements. So again, this becomes the kind of issue where you examine it from multiple directions, and what you find is that either the guy is the biggest BS artist come along, or he's that handicapped guy with the cloud over his head that just seems to where trouble can find him. But the bureaucracy, in this case, doing its best, nonetheless has not done things completely properly. I have never upheld myself as a completely responsible, on-time tax-paying citizen. I admitted to that. I consider that a character flaw. I have paid other bills late. However, I have never been an evader. And if so much of counsel's position is based on the innuendo, in the very least, that I am dishonest, then I rebut that completely. At the same time, as a matter of public policy, I recognize the necessity for protecting the public regarding others who are volitionally dishonest and deceptive in what they do. I recognize that. I'm in a quandary, though. I can't work so far because of these applications. I may not have a career as a clinician in medicine. I might have to have a career as a writer, because I have several books underway, but I might have to, either that or I have to dispense marijuana at these clinics to be paid as a doctor that way. Legally, yes. However, not completely consistent with my ethics, as I have explained in my argument. But if that seems to be the only way that I can work as a physician and support my family and make restitution and hopefully be able to make some money so that I can continue to pay for additional legal support, which is not going to be pro bono, so that I can address the issue as an appeal regarding taxes, which I do not owe, then I will do so. I recognize and I apologize for the young energy in my voice at this point. However, in all sincerity and in all humility, with respect to this issue, I feel I have let down the public. Yes, I've let down the public because I know what I do as a doctor. I know what I do as a humanitarian. I know what I do as a father, as a brother, as a son, as a community member, and as a global citizen. I know how many hundreds of people have themselves been let down directly because they get so impressed when they see me or they read about me. And then they look online and they see Beverly Hills doctor arrested for tax evasion. Or they look on the medical board and they see that record. So I know I let them down. I cannot go around explaining my case and all the intricacies to everyone all the time. I know I let down the patients who would otherwise be able to benefit from my care, who cannot benefit from my care because the facility cannot deploy me. I know I let down myself because this particular issue of being late, this particular issue of being in communication with the federal agencies, but not correspondingly, consistently, obligatorily in enough communication with the Franchise Tax Board, has led to the complications in this situation as well. I recognize that, and I accept responsibility for that. So yes, there is an issue of negligence here on my part. There is an issue of substandard irresponsibility. There is not an issue of accountability. My character, I accept 100% accountability. I accept 100% responsibility for what I do. Every word that I speak, every thought in my head, every action that I undertake, I accept 100% responsibility for that. This is how I've always lived my life. However, there is an issue. I would wonder if everyone understands or accepts and deems acceptable that a technicality in interpretation and an application results in a doctor with an otherwise stellar record of 31 years of practice of medicine all around this world is essentially ejected from the practice of medicine forthwith as a result of the application and these inconsistencies in the interpretation and these limiting technicalities. Therefore,
Doctor, I'm going to cut you off because I'm now hearing a repeat of the points you've made previously, and I want to give the panel members an opportunity to ask questions as well, all right?
thank you very much, sir.
All right, do panel members have questions? Of either Dr. Molson or of counsel? Yes, doctor.
Dr. Nelson, borrowing from the legal community, let's say that hypothetically you had the ability to get any kind of work that you wanted in medicine. What would that kind of work be? And tell us how you're qualified to practice that type of medicine.
Okay. The major areas are occupational medicine, primary care family practice, and urgent care medicine. These would be the areas in which I would and have been seeking employment. These areas are going to be most often they're community service, they're community-based. They're indigent care, at least in part, with respect to some of their populations. And I would, because of my probationary status right now, I'm currently limited to practice within the state of California. Under certain exceptions, I would be allowed to seek work outside of California. There are certain exceptions to that, which I have clarified with the probation department. I do have qualifications in many other areas, but these are the areas that would be most relevant, pertinent, within which I have been and will continue to seek employment. My needs would be to, my intent would be to work full-time and overtime, and certainly to be able to earn as much as I can to address the legal matter in terms of cost, and also in the event that there is no success on the appeal, to continue with this payment and retiring the restitution as fast as possible.
So when is the last time that you have been practicing in these disciplines?
Last time I actually saw a patient was 2 months ago. And I've been taken off the schedule since. The reason I've taken off the schedule is because of these limitations, or also the pending status of this hearing. There have been some others who have said, we'd love to have you, however, we're waiting the outcome of the board's decision.
Thank you.
Okay, other panelists, members have questions for Dr. Molson? Yes, sir. Yes, doctor.
Dr. Melson, I do understand about physician's assistant supervision. I work at a large academic institution with physician assistants and all that. So tell me that if that condition is the only one lifted, what are your chances of having a decent employment where your obligations are met?
I'd say that they are less than 50-50, though they at least are real. In other words, I have had because my sample size has grown to 30 plus in the last 2-3 months of rejections. I cannot say that the restriction on physician's assistants supervision is the only or the primary factor. I have not been able to get Medicare provider certification, for example. That is irrelevant of supervision of physician's assistants. Medi-Cal provider certification, board certification, board recertification eligibility reestablished. These are independent of supervision of physician's assistants. The stigmata itself of being on probation, in some cases, my understanding is that that's no big deal. And yet the reality that I'm facing is that multiple insurance companies are exercising their own judgment as to whether they want to insure a doctor with this on his record or not. Again, having nothing to do with my knowledge in the practice of medicine, having nothing to do with the nature of the offense, just simply the fact that it is stated there. And so I just recently had been told here in Southern California. Sorry, I'm in Sacramento. I just drove up last night. I was just told that we did a review of our insurance providers. This is a medium-sized network of about a dozen facilities or 20 facilities in Southern California They wanted me very, very vigorously to consider them. I had the interview process, everything went very well, but they said in our credentialing, we have to first poll our insurance providers. They had to call me back and said, sorry, Doc, we want to hire you, we'd love to have you, but you'd be providing services that we would not get reimbursed for, simply because of that you have this status. So if we cannot be paid by the insurance companies, we cannot pay you. He said, at best, it looks like about 40% of our carriers would be okay. But do you want to come here and make 40% of what we were very happy to pay you otherwise? So this is part of the reality. I cannot quantify or differentiate, stratify amongst those multiple factors. They are all confluent at this time. Certainly, at the time when the administrative law judge decision was issued from the January hearing of this year, that decision did not factor in, and even that argument at that time by the state or my own counsel did not factor in some of these other issues. That has been empirical. That has been experiential. That has been what has happened as a result of the April issuance of the initial decision. From the beginning of April, when I first received the decision from the board, until the 26th of April, when the decision was supposed to go into effect, I was also working part-time and actively seeking employment. That's when things began to change immediately. I cannot say that if the issue of the physician assistant supervision is the only factor that is addressed, that I believe that I would be able to go out and be gainfully employed and make restitution and continue with my legal case review, simply because we're dealing with the insurance companies in that industry there, and there is great discretion by the providers as to whether they want to insure me or not. And also the fact, of course, that in the environments where I generally will work, these are patients who are covered under third party, particularly Medi-Cal, Medicare. And because I have this on my record, I cannot so far get work even in the federal system. I cannot get work in the corrections system. I cannot get work in the Indian Health Service, and yet I get recruited, so to speak, with over a dozen inquiries each day because of my credentials and my past record. It is indeed a quandary.
Okay, other panel members have questions? Nope?
Yes,
Okay,
Your Honor, actually, I
I'm
do.
sorry, go ahead.
For the, ma'am, your name from the Attorney General's office?
Cindy Lopez.
Cindy Lopez. Cindy, if this body was to consider alternatives, you expressed your dismay and your concern that this would set a precedent. Give me context by way of the number of cases that you're currently tracking that are similar to this.
I'm sorry.
Give me some examples. Give me context. So you said that this would establish a precedent.
All right, and let me clarify, because I realize in my papers, I said exactly what I'm asking the panel to do, but I'm not sure if I made that clear today. As it stands now, the discipline is all the standard terms, and respondent is asking for you to lift the PA. And as I argued, he's not even getting any of the optional terms. If you keep the decision as it is now, that's fine. I mean, you have the choice, of course, of adding the optional conditions, but I would implore you not to lift this. Now, respondent makes a very compelling argument, I understand that, for lifting this. I mean, I have two reactions. just on a human level and then as a DAG. And unfortunately, sometimes those are inconsistent. It's very compelling. When I say that this will set a precedent, when these decisions come out, respondents, their attorneys, they talk about these things. I'm not sure necessarily if this is one of them. There are definitely some very high-profile cases that all of you are aware of that people talk about. And if you go and stray beyond these guidelines, my argument is that you're just making it a little bit harder for us when we go to the next case. So I'm not sure if that answers your question. You said
Well,
it put it into...
it starts to, and I appreciate your attempt. You know, statute, regulation, guideline, and understanding that there's less fungibility at the top of that pyramid and more fungibility at the bottom of it. And we're not here to,
Are we the bottom?
I would say, you know, statute is, you know, an act of
Right.
Congress or the legislature signed by the governor.
Right.
Regulation is a little more formal. That's what we're looking to do.
Right, and guidelines list.
Guidelines this. So
Correct.
I'd say more fungible, more flexible. And then in the context of one size fits all, understanding that the goal is a consistent application, and I respect your asserting that. There are some inconsistencies. You, as a argument, conveyed concern regarding honesty, but then also supported the applicant's sincerity. And so there's a little conflict there, and I'm looking for a nexus for addressing how someone's supposed to make restitution and how someone gets out of the quote-unquote system ever if they are then put in that context. In essence, you know, there's a box, check the box. Ban the box? No, check the box. So if you look at it and say, at what step in the process is there ever a way to break out of the process? If you look at it one size fits all, and you look at a consistent application, then we're blind to it.
Correct. Okay. I'm not saying there's one size fits all. The reason why there's model guidelines is because one size does not fit all. Clearly, every case is different. The model guidelines are there for a beginning, and you can either stray from them by going above and beyond because the case is so aggravated, or you can stray from them and not apply all the conditions if the case, and maybe you think this case, there's mitigation. So there is no one size fits all. Again, I've done a gazillion of these cases, and there's not one single case that has the exact same facts as another one. Does that?
I appreciate that. I guess it's, we live in a world of unintended consequences. And so every time there's an action taken, sometimes there's an equal and opposite reaction. And so that's some of what we're trying to listen for, or what I'm trying to listen for here. By the way, listen, I appreciate you answering the question. Thank you.
I have a question with respect to finding 7 in the proposed decision relating to the tax obligations for the 2005 federal tax return. What was the evidence presented that, or upon which the ALJ found an obligation of $126.78 to the IRS and no obligation to the Franchise Tax Board?
I believe that was from the, when we do these conviction cases, we submit certified documents of the criminal complaint and the minute order when they plea. So I don't have the plea in front of me. I believe that was from the plea agreement. And I'm not positive. To be honest, though, I don't remember ever talking about the federal part of it being zero. I do remember the $126 because it was so off from the $139,000 that they originally found. But I believe that was from the plea agreement.
Okay, well, you anticipated my next question. The panel members may be confused, as I certainly was, based on this finding in paragraph 7 and how that squares with this restitution obligation of the Franchise Tax Board. It just, honestly, it just doesn't make a lot of sense to me, just reading the proposed decision.
I understand that, and again, and I don't want to not answer your question, but When we have these cases, we present the ALJ with the certified court documents. That's what was agreed to. Again, if counsel had incompetent counsel, and I hear that, gosh, all the time, if he had incompetent counsel, that's something he has to deal with in his criminal appeal. And again, I don't mean to sound disrespectful, but that really is kind of irrelevant to our case. I don't know why there is such a discrepancy between this restitution of $139,000 and then this tax liability for $126,000. That did not come out in our hearing.
Okay. Any other panel members have questions for counsel or Dr. Molson? Nope. I think the panel is going to, I know the panel is going to meet in executive session now and decide this matter. And Doctor, do you want to set a time to begin the next, because I think that was supposed to start at 10:15. That's not going to happen, so.
It'll start as soon as we finish our decision.
Okay, all right.
Okay, so they can just wait outside. So we'll move now into closed session.
Thank you.
Board of California, we're now back in open session, and I'd like to turn over the session to Judge Engelman.
Okay, Jody, we're ready down there? Okay, we're on the record in the matter of the petition, I'm getting a little echo here, aren't I? For penalty relief of William Y. Moores, MD, Physicians and Surgeons, certificate number G28505, case number 26-2011-217327. My name is Carl Engelman, Administrative Law Judge assigned to hear this matter. We're convened in Sacramento, California on the morning of July 18, 2013. And I would like the panel members, even though you did so in the earlier matter, and during roll call to identify yourselves for the record, please.
Jerry Shipsky. Dave Ganade.
Denise Pines.
Phil Tagami.
Thank you. And may I have the appearance from the representative from the Department of Justice, Office of the Attorney General?
Good morning. I'm Deputy Attorney General Esther Law, appearing on behalf of the state of California.
Okay, thank you. Dr. Morse, are you here?
He's not here. He made no submission.
Let's go off the record. You obviously, you know him on site or by,
Yes, I would recognize.
have you seen him this morning?
Not seen him, no.
Okay.
I also, as far as I know, I didn't receive a written argument from him.
I didn't see one in the file. Well, that's a good question. That's a good question. The board has non-adopted the proposed decision before rendering its own decision. The board has to offer oral or written argument, and well, I guess by statute, the board must offer both the opportunity for written argument and oral argument. I think the medical board. Do you remember?
I don't know.
This is the place for the presentation of such argument. There is, at least in my view, there seems to be a legal issue that the panel probably has to grapple with. I guess we should, what's your view on whether we should proceed with oral argument in the absence of Dr. Morris, Ms. Law?
I don't know if it's required. I don't think he's asked for one, and we've given him notice that there would be one, though. Again, I've submitted a written argument, and I'm happy to stand by that, but I'm also happy to answer any questions, or I've written out a spiel to present today, and I'm prepared to give that as well, too.
Okay, all right, let's go back on the record. Okay, this matter was noticed for 10:15 this morning. It is now 10:30 a.m. There's not been any appearance by Dr. Moores, nor by anyone on behalf. Ms. Laws indicated she is prepared to augment her written argument, this matter, with an oral presentation. So in the absence of Mr. Moores, Ms. Law, proceed.
Thank you. This was a petition for termination of probation case, and so the burden was and is on Dr. Moores to demonstrate that he's entitled to termination of probation. And the main issue in this case is whether Dr. Moores, whose probation was told for non-practice, has been engaged in the practice of medicine to warrant termination of his probation. And I'd like to just briefly go over the factual and procedural background, because I think it bears directly on the issue of whether the board properly told his probation. In January of 2001, an accusation was filed against Dr. Moores, who specialized in cardiothoracic surgery. And the accusation alleged 9 causes for discipline, including gross negligence, repeated acts of negligence, and/or incompetence with respect to Dr. Moores' care and treatment of 8 patients. Dr. Moores eventually entered into a stipulated settlement where his license was revoked, but the revocation was stayed, and he was placed on a probation for 5 years. And that stipulated settlement was adopted as a decision by the board and became effective in November of 2001. And one of the conditions of the stipulated settlement and the decision was Condition 21, which provided that if Dr. Moores did not engage in the practice of medicine as defined under Business and Professions Code sections 2051 and 2052 for a period exceeding 30 days, his probation would be tolled. Now, 3 days after that effective date of decision, Dr. Moores met with his probation officer, Ms. Katerina Lee, and he informed her at that time that he was currently not practicing medicine. And he also told her that he had no plans to practice medicine involving direct patient contact, and that he instead wanted to teach and do research. And Dr. Moores followed up that meeting that same day with a letter to Ms. Lee, and he stated, quote, "For the immediate present, I will declare I am not going to be engaged in practicing medicine," unquote. 2 months later, in January of 2002, Dr. Moores wrote to his probation inspector and stated that his practice situation had not changed since his November 5th, 2001 letter. That is, he was still not practicing medicine. And a year after that, in February of 2003, Dr. Moores told his probation inspector again that he was still not practicing medicine and was instead working as a consultant in cardiovascular surgery and providing expert testimony in malpractice actions in Wisconsin. And all of these facts are undisputed. And because Dr. Moores, by his own admissions, was not practicing medicine and had not been practicing medicine since the beginning of his probation, the board told his probation consistent with Condition 21 of the stipulated settlement and decision. And it was not until the board told his probation that Dr. Moores claimed for the very first time, and in direct contradiction of all his prior statements to the board, that he had been practicing medicine, that he had been practicing general medicine all along since 1998. But Dr. Moores admits that he does not keep a log of any patients that he sees. He does not maintain records for any patients. He doesn't document any advice that he provides to patients. So there's no corroborating evidence to support his claim that he sees or treats patients. Now, at the hearing before Judge Astle, Dr. Moores testified that his practice basically consists of giving advice about nutrition and healthy living. And he referred to an article he had written entitled Food Rules for Healthy Living, as containing the core of the advice that he gives to his patients. And that article was submitted into evidence as Exhibit 10. And he characterized the advice that he gives in these articles and to his patients as preventative medicine, and therefore falling under the definition of practicing medicine under Code Sections 2051 and 2052. But if you look at his article carefully, what Dr. Morris is doing is he's simply providing nutritional advice that parrots advice that's been provided by Michael Pollan and other non-physicians. In fact, if you turn at the first page of his article, he states that his food rules boils down to the following 8-word rule, which is eat real food, not too much, mostly plants. And if you've read any of Michael Pollan's books, you know that comes directly from Michael Pollan's book. And Dr. Morris acknowledges that in his article, that this 8-word food law comes directly from Michael Pollan, and that his article basically just elaborates on this basic food law. And Dr. Morris has written a second article called Food Rules for Bohemians, which is Exhibit 11, and that article also is parroting Michael Pollan. And again, in that article, Dr. Morris says that he pleads guilty to being a word thief and using Michael Pollan's writings as my basis for Bohemian food rules. So again, if you look at his advice, it's no different than advice provided by Michael Pollan and other non-physicians. And I just want to quickly go over some of the additional rules that is based on the basic food rule to eat real food, not too much, mostly plants, to demonstrate the generic aspect of this advice. Rule 1 was to avoid or minimize processed industrial foods. Rule 2 is to avoid or minimize foods containing white flour and refined sugar. Rule 3 is size matters, control portion size. Rule 4, limit your consumption of bad fat. Rule 5, non-industrial animal products containing cholesterol and naturally occurring fats are not bad foods, enjoy them. Rule 6 is take omega-3 fatty acid supplements. And Rule 7 is pay more, eat less. And again, all of these rules come from Michael Pollan and other non-physicians. I'd like to go over Business and Professions Code Sections 2051 and 2052, because those are the relevant statutes. Because, again, under his stipulated settlement and the decision, he has to be practicing medicine as defined under these two statutes. And it is the Attorney General's position that Dr. Morris is giving of generic nutritional advice does not fall under either of these two statutes. Section 2051 provides, quote, the physician's and surgeon's certificate authorizes the holder to use drugs or devices in or upon human beings and to sever or penetrate the tissues of human beings and to use any and all other methods in the treatment of diseases, injuries, deformities, and other physical and mental conditions. And it's clear that Dr. Morris is not using any drugs or devices. He's not severing or penetrating the tissues of anyone, and he's not using any other methods to treat any diseases, injuries, deformities, or physical and mental conditions. He's simply giving generic nutritional advice. Section 2052 concerns the unauthorized practice of medicine, and it provides, among other things, that any person who practices any system or mode of treating the sick or afflicted in this state, or who diagnoses, treats, operates for, or prescribes for any ailment, blemish, deformity, disease, disfigurement, disorder, injury, or other physical or mental condition of any person is guilty of a public offense. And again, if you go through the statute and you compare it to what Dr. Morris does, He's not treating the sick or the afflicted. He's not diagnosing anyone. He's not treating anyone. He's not operating for anyone. He's not prescribing for any ailment, blemish, deformity, disease, disfigurement, disorder, injury, or other physical or mental condition. Again, he's simply giving generic nutritional advice that's been given by many, many non-physicians. And I do want to point out that from a practical perspective, if the giving of generic nutritional advice is to be considered the practice of medicine, then the practice requirement that's a condition in the settlement agreements and the stipulated settlements would be rendered meaningless, because any physician could say that I give nutritional advice, I tell people not to eat high foods with white flour or sugar, and that's considered to be the practice of medicine. And if anyone can do that, there's no purpose of having a practice requirement during probation. Now, the ALJ found that the nutritional advice that Dr. Morris gives does constitute the practice of medicine, but she relied, and she improperly relied, on the testimony of Dr. Gardner to make this finding. And Dr. Gardner's opined that Dr. Morris's activities is considered to be preventative medicine and falls within the scope of sections 2051 and 2052. But Dr. Gardner is not competent to render an opinion on the scope of sections 2051 and 2052. That's calling for a legal conclusion, and an expert is not authorized to testify as to legal conclusions in the guise of expert opinions. So for that reason, her reliance on Dr. Gardner was improper. And additionally, Dr. Gardner is not licensed to practice in California. He's never been licensed to practice in California and has never practiced in California. And his testimony indicates that he really has no knowledge of the standard of practice in California when treating a patient, because he testified that the standard of practice does not require a physical examination before making a diagnosis, that doesn't require taking a history, and that there's no requirement that a doctor maintain records of patients that he treats. So I think Dr. Gardner's opinion as an expert on the practice of medicine is highly suspect. But Dr. Gardner did state that a medical license is not required to provide the nutritional advice contained in Dr. Morris's articles. And if that's true, if a medical license is not required to provide that advice, then I would submit that advice does not constitute, the advice in and of itself, without anything more, does not constitute the practice of medicine. The ALJ's proposed decision also references the declaration of Dr. Richard Weisskopf, but that declaration was never admitted into evidence, and so the ALJ's reliance on that declaration was also improper. And I also want to address the issue of rehabilitation, since the board specifically asked for argument on the issue of whether petitioner has provided sufficient evidence of rehabilitation to warrant termination of probation. And the answer to that question is no, he has not. And the ALJ erred in finding that he had, because the ALJ applied the wrong legal standard, in that she found that Dr. Morris had demonstrated good cause when, in fact, the burden of proof of showing rehabilitation is clear and convincing evidence. And the ALJ found that Dr. Morris was rehabilitated and safe to practice medicine based solely on Dr. Morris's testimony that he had no intention of practicing cardiology or cardiac surgery in the future, and that he had demonstrated that he was safe to give advice on diet and lifestyles. But Dr. Morris's testimony that he doesn't intend to practice cardiology or cardiac surgery, that's not sufficient evidence. That's not clear and convincing evidence of rehabilitation. With an unrestricted license, there's nothing to prevent Dr. Morris from returning to the practice of cardiology. And Dr. Morris has not produced any evidence that he's safe to practice as a cardiologist or cardiothoracic surgeon. You know, he was disciplined for numerous instances of gross negligence, and he's required to demonstrate, the burden's on him to demonstrate that he is safe to practice cardiology, that he's been rehabilitated, and he submitted no evidence to do so. So in conclusion, it's the Attorney General's position that Dr. Morse is giving of nutritional advice without anything more is not the practice of medicine under Business and Professions Code Sections 2051 and 2052, and that his probation was properly told. Dr. Morse has not met his burden of showing rehabilitation, and that he is safe to practice without restriction. Accordingly, the Attorney General recommends that the board enter a decision denying Dr. Morse's petition for penalty relief.
Thank you. Questions by panel members? Ms. Law. Dr. Law.
Yes, you made a statement about the practice of medicine having to involve the physical examination of patients. Is that correct?
No, I said the standard of practice when treating a patient or giving a diagnosis might require a physical examination. It was Dr. Gardner's testimony that the standard of practice didn't require a physical examination when making a diagnosis.
You know, one of the things that I have a lot of problems with is people that do utilization review, physicians that do utilization review.
I can't hear you.
I apologize. One of the problems that I have with this definition is that people that practice utilization review who are physicians working for, in general, are insurance companies or third-party people that screen for insurance companies, we believe that, or at least I believe, they practice medicine.
And the board may accept those types of practices as practicing medicine for probation purposes. But
For
under
what?
this- For probation purposes, when a physician is under probation, is that the context that you're looking
Well,
at this?
these people do it all the time. That is their profession.
Right.
They're utilization review doctors that never see or touch a patient. You call them with something and they give you a ruling, and they're practicing medicine.
They may be, but I don't think they're practicing medicine under these two code sections.
Well, I mean, but it's still the practice of medicine, isn't it?
Right, but the probationary condition specifically referenced these two sections.
Okay, all right.
I mean, it was
I can live with
limited to
that.
those definitions.
So I just find it very interesting that the administrative law judge found that the evidence was compelling to terminate his probation. I mean, isn't that interesting that we present an expert from the medical board side, they present one expert and a document, and the administrative law judge concludes that his probation should be terminated.
Well, I don't think it was correct for her to accept expert testimony at all. There was no need for expert testimony, and it was improper to receive expert testimony on the issue of whether
Well, did we have a DAG at that hearing?
we did. I was the DAG at the hearing.
Well, I mean, your arguments obviously weren't very compelling to the administrative law judge,
Obviously not. I
which is the problem that I have.
I think she was wrong.
I think many of us that reviewed this did not feel that his probation should be terminated, yet the administrative law judge decided that it was based on what she heard at hearing. And I think that's what brought this to today's meeting.
Right. I think what Dr. Morris's expert, what he argued, or what his position is, if advice comes from a doctor, that's the practice of medicine. So he was saying, if the doctor is giving nutritional advice, that's the practice of medicine because a doctor is giving that advice.
The only thing that I'm conflicted with is the fact that they were able to convince the administrative law judge. Yeah.
That's why.
Anyway, all right. Any other questions?
Doctor, you had a question?
Yeah, I mean, now I can see what the sections you quoted, because utilization review is practice of medicine. Medical information technology is practice of medicine. If you're an administrator in a hospital where you don't touch a patient, that's still a practice of medicine. We take that all for granted. So if we restrict the practice of medicine to only examining patients, that really concerns me. But now you mentioned that that was in his probation, those two sections. Now I understand that.
Okay.
That's what, but otherwise, what he was doing, you could quasi call it a practice of medicine, even though he might be a danger to the community to do cardiology, which he hasn't practiced for a long time. So that's why that was our concern. So I'm still, like Dr. Lowe, somewhat puzzled and surprised how we, the medical board, lost it out at the ALJ hearing on this issue, where the person hasn't done anything with a patient, and and it doesn't even say that it's lifted with some kind of a significantly restricted license. It just says it just lifted. So that means he can have full license. That's why I'm just puzzled.
Any other questions for Ms. Law from panel members? No? Okay. The panel will meet in executive session, decide the matter, and then issue a decision to be served upon the parties. Thank you, Ms. Law.
Thank you.
Off the record.